Okay, hello everyone. My name is Mo Kebeh, and I'm an associate at Gill, Israel, and Krasnoff, and I'm the program chair for this event. As moderator, we have Zev Shechtman, who is a partner at Gill as well. Zev represents debtors, trustees, and other parties in bankruptcy and other insolvency matters. For panelists, we have Roye and Trisha Gum. Trisha is a partner and founder of Film and Ink Law Group. In her practice, Trisha primarily represents major studios and individual talent in development, production for motion pictures and episodic series. Roye is a partner at Elkins, Kalt, Weintraub, Reuben, Gartside. Similar to Zev, Roye represents parties in bankruptcy and restructuring transactions. Just a couple of notes before we get started here. All attendees should have received an email with the program materials attached about an hour ago. Additionally, all attendees will receive their MCLE certificates within 24 hours after the close of this event via email. There should be a link to a survey in the same email. We also have some time reserved at the end of this event for questions. So if you have any questions during the program, feel free to write them down in the Q&A chat at the bottom of your screen, and we'll go over them at the end. From there, I'll let you take it. Thank you.
Thank you very much, Mo. Thank you, everybody, for joining us today. On behalf of both the bankruptcy section and the entertainment section of the Bar Association, we're happy to have you and happy to be able to present to you about the silver linings of the Weinstein Company bankruptcy case, if there are any. For the entertainment section, I'd like to make a couple quick announcements. Entertainment section meetings are the first Wednesday of every month at 8:30 a.m. All are welcome to participate via Zoom. To get on the invite list, simply contact the BHBA office and they will send us your email address and it'll be added to the list. The entertainment section's next program is scheduled for lunchtime, Tuesday, May 25th. It'll look into and address issues regarding Section 230. We're having Congressman Adam Schiff's chief of staff scheduled to participate. So to kick off this program, I'm going to cover a few of the basic aspects of bankruptcy. Bankruptcy can affect virtually any kind of business. Almost any kind of business can find itself in bankruptcy. And guess what? That includes entertainment businesses. The Bankruptcy Code is Title 11 of the United States Code, and that determines how parties are treated in bankruptcy. The Bankruptcy Code says what property can be used to pay creditors, and it describes the order and priorities in which creditors get paid. The Bankruptcy Code provides certain protections, benefits, and obligations for debtors and creditors. Critically, the bankruptcy filing creates an automatic stay, meaning that it stops litigation and collection efforts against the debtor, and it prevents actions against the debtor's property. The bankruptcy process is also designed to protect creditors. Creditors typically don't want to see their debtors go into bankruptcy, but sometimes through luck or careful planning by the creditors, they may find themselves in a relatively good position in bankruptcy. For example, creditors who have a security interest, meaning a lien or mortgage that is secured by valuable collateral, they can get paid from that collateral ahead of other creditors. Bankruptcy also has special treatment of certain types of contracts. Entertainment companies, as many of you know, typically have a lot of contracts. In some of the larger bankruptcy cases that we've seen, there are thousands or even tens of thousands of contracts that were dealt with in the bankruptcy case. Much of what we're going to cover today focuses on those kinds of contracts. Contrary to the popular opinion of the drafters of boilerplate, a provision that says that a contract becomes automatically void upon the filing of a bankruptcy petition is itself void in bankruptcy. we actually need to deal with contracts in bankruptcy, whether we like it or not. Bankruptcy has a special category called executory contracts. This is covered by Section 365 of the United States Bankruptcy Code, Title 11. According to a famous professor named Vern Countryman, an executory contract is a contract under which the obligation of both the bankrupt and the other party to the contract are so far unperformed that the failure of either to complete performance would constitute a material breach excusing the performance of the other. Say that 5 times fast. The reason why we have this definition is because it's not defined in the bankruptcy code, even though it's very important. To say it more simply, executory contracts are contracts where performance remains due on both sides. That's something you might be able to say 5 times fast. So some examples of potential executory contracts, or arguably executory contracts in many cases: film distribution agreements, participation agreements, license agreements, trademark agreements, royalty agreements. There are many other kinds of agreements, as you all well know. Roye, please briefly tell us what kind of contracts were at issue in the Weinstein Company bankruptcy.
So, as you mentioned earlier, an entertainment company that goes into bankruptcy is going to have thousands, if not tens of thousands, of different contracts, depending, of course, on the size of the library, the number of productions that are ongoing as of the bankruptcy filing. And so the Weinstein Company, if I remember correctly, when it filed its bankruptcy case, it teed up a sale to a company called Lantern, which is now known as Spyglass. And as part of the sale, as is typical in sales that are conducted in bankruptcy cases, there was a notice put out of containing lists of contracts that potentially may be executory, of course, with all rights reserved, to argue that they're not executory, and that the purchaser potentially may take as part of the sale, either as an assumption and assignment, which we can discuss later, or as an asset to be purchased in the sale itself. And that notice contained tens of thousands of contracts. I think because of the quality of the records that the Weinstein Company kept, which was, as I understand it, less than perfect, the descriptions of these agreements was sometimes pretty vague, and it was difficult to figure out what exactly the contract was, except if you were the counterparty to that contract, you might be able to figure it out because you have a personal recollection of what the issue was and what the contract was. But in many cases, we had clients in that case where they just couldn't tell if the description in the notice itself was referring to the specific contract that we thought it was referring to. So to answer your question, what types of contracts? There are all kinds, but the very common ones were license agreements, obviously, domestic and international. There were participation agreements with certain talent, producers, writers, directors, actors, and others. There were distribution agreements, and I believe there were trademark agreements. There were also a lot of music related agreements that pertain to music that was used in films. But of course, that falls under the umbrella of license agreements. The contracts that we dealt with specifically at great length were participation agreements of our clients. So we represented a lot of a lot of actors and directors and producers of various films that were made and released by the Weinstein Company, including Silver Linings Playbook, which was a very successful film starring Bradley Cooper and Robert De Niro and directed by David O. Russell. So that was really the star. When I say successful, not just critically, and I think it was nominated and won Academy Awards, but also financially. It was a very successful film for the Weinstein Company.
Thank you so much, Roye. Trisha, as an entertainment lawyer, it's really interesting to hear what you think about bankruptcy and so what are some of the insolvency-related entertainment issues that you are concerned with?
Well, in the events, you have a single purpose vehicle producing a project for a studio. And if the studio has a perfected security interest in the collateral that the SPV is producing for the studio, what happens if the SPV's parent goes bankrupt?
So the first question any bankruptcy lawyer is going to ask is underscore if the studio is perfected. The next question is whether the collateral is actually worth anything. If the answer to both is yes, then the studio is in a really good position and is ultimately entitled to the collateral or the value of its collateral. But once if the creditor it doesn't have a properly perfected security interest as of the time the company files for bankruptcy, it's out of luck. It's going to be treated like a general unsecured claim. And also, you can have a security interest in something that has no value, in which case you're still going to be a general unsecured creditor. You're going to be treated like all the other creditors if the stuff, the collateral in which you have a lien, a security interest, doesn't actually have value.
Okay, so it sounds like it's very important to perfect your security interest.
Absolutely. For example, if you've got certain types of personal property, the proper way to perfect that security interest is most likely going to be to file a UCC in the correct state, a UCC1 form, a financing statement. And there's many cases addressing how to do that and how to not do that. Because if that gets messed up, it could be a $1 billion problem, as we've seen in cases in the past few years.
And of course, the issue would come up if a security interest is unperfected, then there may be a lien, right? But it would be subject to avoidance, or it would be inferior to rights that a bankruptcy trustee or the debtor in possession could assert as a hypothetical lien creditor with rights that would be senior to the unperfected lien holder, right? So that would be the cause of the $1 billion problem, as you say.
Sure. And even if everything was done right, the timing might be such, or the transfer, the creation of that lien might be subject to attack in bankruptcy under some of those same theories. Sections 544, 547, 548, and others of the bankruptcy code that provide for avoidance of transfers that are either preferential or fraudulent. But that's a little bit beyond the scope of this program. We'll do that in another bankruptcy program. Stay tuned. And then another important point is don't assume that filing a UCC with the Secretary of State in California or Delaware or whatever the correct state might be for that particular thing is the end of the analysis. You might also have to file or record something with the Copyright Office in Washington. And it's okay to file in more than one place for belts and suspenders. But if you choose one only, and that's the wrong one, you may be out of luck in the event of bankruptcy. Back to you, Trisha.
Great, good to know. Thank you. Well, we often deal with co-productions in entertainment. So what would be the differences at play in bankruptcy if a film is a co-production where each party owns 50% of the copyright?
So when I think about this, I think about what is the ownership structure. So for example, if the 50% copyright ownership is owned by the debtor in bankruptcy, that is, the debtor, the company that's in bankruptcy simply owns 50% of that copyright, that debtor may be able to sell that fractional interest, that 50%, under the bankruptcy code. Probably would be. I mean, that would be the goal in bankruptcy, to monetize that interest. And Section 363 of the bankruptcy code allows the debtor to do that, even over the objection of a co-owner, under certain circumstances. Now, what if the owners each own 50% of an entity that owns the copyright? Not an uncommon structure. Then the debtor's estate can only sell the equity interest in the company. That's what the debtor owns. And they would need to comply with the corporate and contractual requirements of that entity to take any action with respect to the copyright interest itself. So that layer creates a little bit of complexity. Roye, how were rights structured in the Weinstein Company case?
So what we dealt with specifically was it came up in a little bit of a different context. But to go back to Silver Linings Playbook, for example, remember what the Weinstein Company was selling was whatever rights it had with respect to that film. So there was obviously the copyright, but there was also a bundle of rights that were obtained by the Weinstein Company, at least allegedly, as with different talent parties, among others, by the way. But the most valuable ones would have to be the intellectual property that goes into the making of a film. So the issue actually came up when the question was really asked by various objecting parties, not necessarily to the sale, but to the assumption and assignment of contracts. The issue came up in that context where the objecting party said, "Hey, all these contracts that you've listed in your notice are contracts between our clients and some non-debtor, and the non-debtor was this production entity, what they've called the contractor, right? Well, when did the rights ever? Let's just say the talent transferred their intellectual property to this production entity, but from that point, where did the rights go, and how did they end up with the debtor so that the debtor could then sell those rights together with the copyright and everything else to the buyer? And so, we went through basically a little mini trial on this issue, but what we got out of it was that, and this is just a very general description. Obviously, it was much more complicated, but this production entity, non-debtor, would be formed by the Weinstein Company. And it was not a subsidiary of the Weinstein Company. It was sort of an unrelated corporation. It would enter into individual agreements with the writers, the directors, the producers, the actors. Those are the participation agreements, if you will. And as part of those participation agreements, those individuals would assign their rights in the intellectual property to that entity. That entity would, I think, simultaneously or sometime thereafter, enter into a production services agreement with another entity, single purpose entity, which is a subsidiary of the Weinstein Company. And then that entity would license its rights to the Weinstein Company or other affiliates of the Weinstein Company. And then eventually, at some point, the single purpose entities would be dissolved, and the rights that the subsidiary obtained from the first production entity would, in theory, flow upwards upstream to the Weinstein Company. And so that's what the bankruptcy judge decided in that case ended up happening, and that was it. We still had some sort of lingering questions about how this process actually worked, because all we were really told was that the subsidiary eventually was dissolved, but we were never really shown any evidence of the upstream flow from that subsidiary to the Weinstein Company. But it sort of is what it is.
Thank you, Roye. Trisha, what else can we tell you?
So, we have a production company producing a movie for a studio. And if the production company goes bankrupt during production, so the movie is unfinished, what happens to that collateral if the studio has a perfected security interest versus if the studio didn't perfect its security interest?
Mm-hmm. So I'm just going to say, for hypothetical purposes, that we've got a Paramoon studio, and Paramoon Studio has a movie being produced by Judd Apatite Production Company, and Apatite's production company filed for bankruptcy. So the first thing we need to do is check to see if Paramoon Studio is properly perfected in the assets. If it is, if it does have a security interest, then Paramoon can seek relief from stay, because as I mentioned at the top of the program, the filing of a bankruptcy petition creates an automatic stay, which prevents any action to collect or repossess assets or anything like that. So Paramoon would seek relief from stay to foreclose on its collateral or otherwise pursue its remedies. Now, if the asset is underwater and completing the production of Apatite, or the production by the Apatite company is unlikely, we'd have a good shot at getting relief from stay under Section 362. On the other hand, if this production is going well, despite the bankruptcy, and Apatite is looking, has a viable shot at reorganization, you're probably not going to get relief from stay on your first attempt in the scenario that I just painted in very broad strokes. Now, without a security interest, you're not going to be able to do those things. But having an executory contract becomes very important in that situation. And Roye, could you tell us a little bit more about the Weinstein Company and the executory contract issues that you have been dealing with?
Sure. So as I mentioned earlier, as part of the sale, the Weinstein Company published a list of contracts that it had with third parties that the purchaser was interested in acquiring. Now, in bankruptcy, there are two ways to take a contract, and it really depends on the nature of the contract, whether or not it's executory. If it is executory, then the only way that a purchaser can acquire that contract is through the assumption and assignment procedure in Section 365 of the Bankruptcy Code. The assumption of a contract, in turn, requires the cure of all defaults that are present at the time of the petition date, and actually anything at the time of the assumption, really. So a full cure of all defaults. If a contract is not executory, then it could simply be sold free and clear. Now, the question, what does free and clear mean? also came up in the Weinstein case, but I'll get to that a little bit later. So those are the two ways to acquire a contract. The dispute that came up was whether or not these contracts of the talent, these participation agreements, whether they were executory. And the reason why this was a critical question is there were defaults in the millions of dollars at the time of the bankruptcy that for obvious reasons, the purchaser did not want to pay. And so the purchaser took the position that the agreements were all not executory because the films had been made, and therefore that it simply acquired the contracts as part of the sale, free and clear. They took the position that free and clear meant they didn't really have to perform going forward either, that they just acquired the asset, meaning the intellectual property, and that was it. The bankruptcy court decided that no, even if the contract is not executory and you acquired it, you took it as is and were obligated to perform under the contract all obligations that arise post-closing. So the issue still, the issue that was obviously dearest to us was whether the contract was executory. And to go back to the test that you mentioned, Zev, the countryman test, just to reiterate it, it looks to see if the contract is still capable of being materially breached by both sides. So it has to be unperformed to the level that it could still be materially breached by either side. The bankruptcy court looked at these contracts, which had some obligations still remaining. And in particular, there was one contract that was before the court. Actually, it came up in a test case. And it was a gentleman named Bruce Cohen, who was one of the producers of Silver Linings Playbook. Bruce Cohen still had several ongoing obligations. So, for example, he had an ongoing indemnification obligation, in the event that anybody sued the studio for infringement or something having to do with the material. There was a whole procedure in place relating to his right of first opportunity to produce a sequel or some related production. Obviously, the Weinstein Company was still obligated to account and to pay contingent compensation. This isn't related to Bruce Cohen's agreement, but for the actors, for example, there was an ongoing obligation not to speak ill of the film, not to trash it in public for obvious reasons. And then in general, there were some continuing warranties. All of the talent were obligated, for example, not to sue for an injunction in the event that they weren't paid. For obvious reasons, right? If you're a studio and you fail to pay your profit participants, you don't want there to be some risk that someone's going to enjoin your continuing ability to exploit the film in the event that you don't pay them. So they could only sue for money damages. So the bankruptcy court took a look at this. It applied what's known as the substantial performance test under New York law, and it said, look, these contracts, these films, Silver Linings Playbook, and specifically, it was released 6 years prior to the bankruptcy. Bruce Cohen finished producing the film. He gave the services that he was required to give, and yes, he might have had some continuing obligations under the agreement, but they're not material. And so therefore, he has substantially performed the agreement and is no longer capable of breaching it materially, which would, which would permit the Weinstein Company to suspend its own performance under the contract, i.e. stop paying him. There is a case in the Third Circuit called General DataComm. It's a 2005 case. And what that case says is the most important thing that you have to do is look at what does the agreement say, okay? The question of what is a material breach is it comes out of the restatement of contracts. It's a, there's a list of factors that you look at to see if particular terms are material. But what General DataComm said was if the agreement defines materiality, then that's the analysis that you engage in. You don't sort of second guess. You don't substitute your analysis of what's material for what the parties have agreed is material. And so in the Bruce Cohen production services agreement, there was a very clear provision that said Mr. Cohen will get his contingent compensation so long as he doesn't breach any of the obligations of this agreement. That's it. So if he is in breach of any obligation under the agreement, then the Weinstein Company no longer needs to pay him. So we argued, look, this is actually pretty straightforward. And whether we think the indemnification obligations, for example, or any of the other ongoing obligations are material, it really doesn't matter what we think of them. Casual observer may say, look, these aren't very important. But regardless of our opinion, the parties have agreed that only complete performance will suffice. Meaning, if there's any breach, the Weinstein Company no longer has to pay him. And so we argued that General DataComm was applicable and controlled the outcome of that case. And the bankruptcy court disagreed. It relied on a case called Kintex, which is an old case, actually originating here in the Ninth Circuit. It had to do with George C. Scott. And the case just very generally says if a movie was made and the actor no longer has any material ongoing obligations, then the contract is not executory, and there's no need to go through the whole cure process. The contract can simply be sold. And so we appealed the bankruptcy court's decision to the district court. The district court, affirmed the bankruptcy court's decision, and then we took another appeal to the Third Circuit, which actually in January of this year, this goes back, by the way, to early 2019, but finally in January of this year, the Third Circuit held oral argument and asked very interesting questions at the oral argument. So I think they're going to take a very, very close look at it. One of the questions that Judge Ambrose, who was on the Third Circuit panel, who's a former bankruptcy practitioner, actually, one of the questions that he asked was just point blank: is this contract going to be executory forever? Because the obligations are, they don't have a time limitation, right? I mean, practically speaking, there's only so long that someone can sue for an infringement, for example, right? There are statutes of limitation, but the obligation, in theory, that Mr. Cohen has will go on forever. And so the question was, is this contract going to be executory forever? And the answer is yes. I guess if that's what the parties have decided, then that's what you defer to. And that's specifically what General DataComm said. There was a dissent in that case, or actually it was a concurring opinion, but the concurring opinion went through a very long analysis of, why the obligations in that case were not material. And the majority said, look, we appreciate your analysis, and it's very well reasoned, but it's really irrelevant what any one of us thinks is material or not. What matters is what the parties have agreed to, and if the parties have agreed that only complete performance will suffice, then that's the answer. So we hope to get a decision out of the Third Circuit pretty soon to put this issue to bed. It would have been very entertaining if we actually had a decision for this panel, but we can't control when the Third Circuit's going to decide this thing. It could be tomorrow. It could be in 6 months. Who knows?
And do you anticipate that someone will take an appeal or seek to appeal to the Supreme Court?
I don't think so. It's not really, Supreme Court. The Supreme Court might be interested in resolving a circuit split, for example, but this is so fact specific. And there's really no question, about what test applies, for example, right? I mean, the Countryman test applies. I think most circuits apply that test. There's some variation of it that other circuits use. But I don't think it's an issue that anybody really thinks that the Supreme Court would be particularly interested in, aside from the parties involved. So, I mean, that's not to say that, someone won't try to get, further review of the decision, but I think this may be it. So,
Trisha, how do you feel about the substantial performance test?
Well, the substantial performance test was frustrating. It's because in the entertainment setting, the material obligations of contracting parties often arrive at considerably different points in the contractual relationship. And here, the agreement was only substantially performed to the benefit of the Weinstein Company, which saw its movie released. And the Weinstein's obligation to pay back end to Cohen, it doesn't end upon release of the movie. Back end obligation only begins upon release, when the movie starts earning receipts and can recoup its debt. So to Cohen, getting paid his back end, it's a material obligation of the Weinstein Company. And I just think the substantial performance test is inappropriate for this situation because Weinstein didn't substantially perform its contractual obligations to Cohen. Entertainment agreements require full performance, and that performance can go into perpetuity as these, films earn money for their entire existence, different exploitation of different media.
Actually, it's funny that you say that because they did make an argument in their papers on appeal that this is the purchaser Spyglass that even as to the Weinstein Company, now Spyglass, there was no material obligation remaining, and they took the position that because the contract could no longer be rescinded by Mr. Cohen because he had transferred his rights in the IP at the time that he entered into the agreement, and because he was limited to money damages, that this contract was no longer capable of material breach by either side, which, for the reasons you just stated, makes very little sense because the contingent compensation part of this contract is a really, really important thing to the talent. Mm-hmm. And by definition, it doesn't come into play until sometimes well after a film is released, because it takes time to recoup all the expenses. And so, the panel, the Third Circuit panel, thought very little of the argument, but it was interesting that they even made it because it doesn't really make much practical sense, or legal sense for that matter.
No, I agree. I think the DataComm, the unperformed employee benefit plan under that case, it seemed just very similar to Cohen's situation, where his back-end compensation was akin to an unperformed employee compensation plan. He had to sit and wait for it. And, their materiality was determined by the intent of the contracting parties, which I think is a much better test for entertainment agreements.
Right.
Well, Roye, to push back a little bit from the bankruptcy perspective, I mean, isn't it commonly said about executory contracts that a mere financial obligation does not render an executory contract a contract executory?
Right. I agree with you that generally, if there's just the payment of money involved from one side to the other, that would not by itself make the contract executory. But here there was, so you have to look at it from both sides, right? What's the obligation remaining on both sides? From the Weinstein company's perspective, they still had to not only pay but also account. Send accounting statements to the participant, either quarterly or annually, depending on the situation. They were obligated to participate in an audit if one was commenced, and there's a whole set of procedures for that. And then from the other side, of course, what we argued was that there were continuing obligations that were owed by Cohen to the Weinstein company. So it wasn't just the mere payment of money that was involved here, right? It wasn't just a promissory note, for example. So it was all of that together that made the contract, at least in our opinion, executory, not simply the mere payment of money.
Understood. Trisha, I think you have some more questions about some of these issues.
Yeah, having worked at a guild in the past, I'm curious, how are past due residuals handled in the Weinstein bankruptcy? Is Spyglass required to pay the past due residuals that were owed from Weinstein's exploitation of the movie?
So we didn't really get involved in the guild issues. The guilds are very well represented by a gentleman named Joe Kohansky, who represents the guilds in seemingly all of these cases and has done so for decades. But as I understand it, the guilds have obviously security interests, so their issues are going to be slightly different from the issues that we faced. But I actually think that they just, they had a dispute between Spyglass and the guilds that might have been settled as recently as 2 or 3 days ago. I haven't had a chance to look at the papers yet, but if we have a follow-up to this, I can fill everybody in. But again, the issues that come up in the residuals context with the guilds are very, very different from the participation agreements, which are not negotiated on a collective basis. Of course, they're individual participation agreements with different economic deals made by the talent and the studio.
Okay, so we'll back to those participation deals and agreements. If Spyglass had assumed the past due participant obligations, all the back-end payments, how would Spyglass ensure accurate reporting of gross receipts, production, marketing costs that they were not involved in? And how would they even afford it? It must be millions of dollars.
So as you can imagine, they didn't go into this blindly, right? They probably did months of due diligence, which probably wasn't enough, but they did months of due diligence on the Weinstein company. And when they bought the Weinstein company assets, they also took with them a bunch of the employees that worked in that department, in the participations department. And so, presumably they would get that institutional knowledge and also the books and records to be able to calculate, or at least to verify that what was transferred over by the Weinstein company, those figures were actually accurate. But there were a lot of questions about whether the numbers in these accounting statements were accurate, because they didn't have the greatest of reputations as an accurate reporter of costs, of expenses, and of revenues.
And with the millions of potential back-end participations that's owed, is that calculated into the purchase price? How does that work?
So generally, yes, it is. In this particular instance, it was actually very interesting because, and Zev, you'll appreciate this. I mentioned earlier the cure costs. And typically, the obligation of who pays the cure costs is negotiated between the purchaser and the debtor, right? So it's a question of whether the money comes off the gross or the net, right? The purchase price. And this is usually negotiated and agreed to, and there's no dispute that comes up before the bankruptcy court. In this particular instance, after they negotiated, I believe it was a $310 million purchase price for the Weinstein Company's assets. The dispute came up of, well, who pays all these cure costs? And there were tens of millions of dollars. Eventually, what they did was they agreed that Spyglass, the purchaser, would pay it, but that the purchase price would be reduced by $21 million. So you would think that the purchase price that they negotiated originally would take this into account, and that they would figure out who's paying this stuff. But they didn't do that, and eventually they got a $21 million price reduction, which ironically they didn't necessarily use to pay the cure costs, which they originally said were going to be all these participation agreements, which they then said, oh, we don't have to pay those because those agreements are not executory. It was an odd chain of events, and one that we thought was very unfair and dishonest. But to answer your question, yes, it should be part of the purchase price, and simply saying that the purchaser is going to have to pay the cure costs and the participation, whatever's owed as of the petition date for the participation agreements. You would think that would just be something that goes into the decision to buy a company like this and how much money to pay for it. So
now, is there any silver lining for the folks who are subject to agreements that have been acquired by Spyglass, when Spyglass, for example, exploits those rights on a go-forward basis? Does Spyglass get to do so without having to pay anything on the downstream, go forward basis?
Right. So as I mentioned earlier, there was a positive finding made by the bankruptcy court, which was not challenged on appeal, and that was that if you take a contract, you take it what's known as cum honore, right? You take it with all of its obligations, at least going forward. And so for Spyglass, they had to, pay whatever arises post closing, whatever amounts come due post closing, and they would have to account, and they would have to, respond to an audit, and whatever the contracts provide, they would have to honor on a go forward basis. So that was one thing that, you would think is a pretty straightforward, legal principle, but there was some argument about it, and it was good that it was at least laid to rest as an open question.
Yeah, I mean, interesting, just from a business perspective, how Spyglass would do business on a go forward basis without the court ruling that way. How it would be able to work with all these people that would feel very offended by the fact that Spyglass can continue to exploit their work product without paying them anything.
Yeah, the message was sent in multiple ways and numerous times to Spyglass, and they responded by saying all the right things, but But for some reason, they just continue to take this sort of very aggressive position. But I'm not aware of any films that they've actually released. So who knows?
So, learning the lessons of this case, let's talk a little bit about how we can protect clients such as Trisha's moving forward from here. Trisha, how can we resolve some of these issues?
Yeah, how can entertainment attorneys avoid problems like this? And how can we protect our clients from a bankruptcy to ensure our clients are paid contingent compensation, whether it's back end for talent or royalty payments from a distributor?
So I think we started out with security interests. I think the special purpose vehicles are kind of a double-edged sword because on one hand, they can be used to isolate the exposure for the investors or the creditors. On the other hand, they can be kind of used in a way to shield and transfer assets that make it harder for creditors. So ultimately, it comes down to business. It comes down to trust but verify, making sure that that you build in the kinds of protections into your agreements that give you transparency, that don't create overly complicated structures, and that you really trust who you're doing business with. Because I think a lot of the bad provisions that people dealt with in cases like the Weinstein Company case had to do with leverage in the negotiating process, and then not being able to address accounting issues going forward, and being shut out of the auditing and accounting protections that they bargained for in the ordinary course pre-bankruptcy. Roye, what do you think?
Well, specifically on the participation agreements, obviously, as a talent party, you want them to be executory. And obviously, none of these agreements were drafted with bankruptcy really in mind, and definitely not with the whole executory contract question in mind. But sitting here today, if you want to make the contract more executory, it's a little bit of a double-edged sword, because to make it more executory, you have to also make it so that the client, if the client is a talent party, you'd have to make it so that the talent party could still materially breach the agreement, and that would in turn give the studio an out from paying. So it's a little bit awkward, right? You want to protect the client in the event of a bankruptcy, but if there is no bankruptcy, you're leaving the door open for the studio not to pay. So I'm sure a lot of the very creative, clever minds who are watching this can think of ways around it. But one way around it may be to just build in a cure period, right? So it's not, you don't shoot the talent party too much in the foot. You allow that individual to cure any default, and therefore, while it still could lead to a material breach, which would then allow the studio to stop performing, i.e. to pay, there's this cure period which allows them to cure the default. So you could still have an executory contract, but at the same time, not harm the talent party in the process.
Okay. I think that marks the end of the discussion section of our program. We have quite a few questions here, so I'm going to go through the questions in the Q&A portion first, and I know that there were some questions in the chat as well, so I'll get to those. In the interest of time, I'm going to ask the panelists and our moderator, if he decides to step in, to kind of keep the answer short and sweet. First question that we have here is the licensee of an international distribution rights from Weinstein liable to the purchaser of Weinstein assets for revenues earned but not paid prior to the filing of the bankruptcy? think this is in reference. Go ahead.
Yeah, so I
I'd say
think the
yes.
answer is probably yes under most circumstances.
Yeah, I agree. It would be an asset of the bankruptcy estate that is sold as part of the sale, and the receivables survives and is unaffected by the bankruptcy.
Mhm.
Yeah, I mean, I guess if the licensee had an issue with the sale, it would have, hopefully given notice of the sale and would have objected at the time of the sale. I could imagine various reasons why the licensee, could, not necessarily in the Weinstein case, but in sort of in the abstract, there could be reasons why a licensee would challenge the performance by another party. But if we're already down at this point, the licensee probably doesn't have any basis to challenge the demand for payment.
Okay. Question number 2. Are typical international distribution agreements executory contracts if the film has already been delivered?
So I'm assuming that that this is a license arrangement, and if it is, then the answer is probably yes. There are a lot of cases that have said that license agreements are typically executory contracts because they include, for example, an ongoing obligation by the licensor not to sue for infringement of the IP. But there are some cases that have sort of called that logic into question. So I guess my very lawyerly answer is going to be it depends.
Yeah, I think that it depends is correct, and I think that this kind of is in a nutshell is the issue before the Third Circuit. It's kind of, it's going to be very fact specific. You're going to have to look at the applicable laws, and I think under, for example, the Ninth Circuit, if you follow the Ninth Circuit Kintex precedent, it would probably go the other way. But definitely room for reasonable minds to differ.
Okay. Question number 3. We have, in a talent agreement, is adding the word material before obligations a bad idea from a bankruptcy point of view?
So I would think that it wouldn't necessarily add anything, right? It would just sort of reinforce the idea that you need to figure out what material means. From our point of view in our case, we liked that there was that the word material didn't appear before the word breach, because a breach is just a simple breach, right? That you don't have to determine that it's material. So long as there was no breach, then Mr. Cohen could keep receiving his contingent compensation. And if there was a simple breach, then he wouldn't. So that, from our point of view, that's what made the contract executory. If the word material had been there, I think it would have muddied the water a little bit. So is it a bad idea? Maybe, but it's a cleaner analysis without it.
Got it. Next question. Wasn't the executory contract issue in the Weinstein case whether the talent had any material obligations that could be breached? Did the court hold that the non-disparagement and indemnification obligations of the talent were not enough to cause a material breach?
Yeah, that's exactly right. The question of whether the question of whether the contingent compensation obligations that the Weinstein company still owed, the question of whether those are material really came up in the briefing on appeal. And as I mentioned earlier, it was sort of just an odd argument to make that wasn't seriously taken by the Court of Appeal. But yes, to answer that question, yes, that's exactly what the issue was. And the bankruptcy court did decide that it was not enough to cause a material breach, the indemnification and the other obligations.
Got it. Next question is, what rights do completion guarantors have in bankruptcy cases generally?
Maybe Trisha, could you give us an idea of what completion guarantees and completion guarantors refers to generally in entertainment?
Sure, if something goes wrong during the production, they will step in and help finance the picture and get it finished so that, obligations can continue, it can be distributed, people can get paid.
So who would be giving that guarantee? Would it be like a principal or equity owner of a producer?
No, more like an insurance company.
Okay. Something to think about. I think they probably they're probably creditors, and I guess if they're creditors of the company that's in bankruptcy, of the producer, let's say the Appetite production company, they would be like any other creditor. And are they secured? Do they have an insurance obligation? There may be rights to that insurance policy. What does the estate have a right to the insurance policy? Creditors, probably third parties who relied on that insurance policy, likely may have claims to that policy. So there's all kinds of interesting insurance issues that could come up.
Okay. And our next question, I'm not sure how well into the details you can get on this, but we have someone that works at a firm that has claims for fraud against the Weinstein company arising out of a film deal. And the question is, how do you determine what % of the monies owed under the contract their client will get? And they note that the appropriate claims were made in the bankruptcy.
I know that there was a disclosure statement and a plan proposed. I'm sure it's been confirmed by now, although I haven't really been following it. But those documents would probably include some information about what the estimated payout to unsecured creditors may be, assuming, of course, that the claim is allowed, meaning that there's no objection that gets filed to the claim. And I don't know if they've gotten to the point where they've filed claim objections yet. Feel free to contact me afterwards. I'm happy to look into it for you. But it's from what I know about the case, there isn't much hope for a big payout to unsecured creditors, which is, of course, why our clients were so interested in getting paid by the purchaser.
Yeah, that's a really good point. The assets, the secured debt was something in either around or in excess of the purchase price, if my recollection is correct. And there wasn't a lot that was going to be available to unsecured creditors from that sale. Just sort of looking at it from 50,000 feet as an observer. And of course, the whole thing about executory contracts and why they're important is that in order to assume and assign them, you have to cure the pre-petition defaults, which means $100 instead of unsecured creditor claims, which is what you would get if your claim is not an executory contract and you're rendered an unsecured creditor.
Right. It's really the difference between being made whole and receiving pennies, if anything, on the dollar.
Yeah.
Right. Moving on to the chat here, I think we have about 3 more questions before we wrap up. The first question, I think, refers to a discussion earlier on in our discussion section, and it reads, if the production company did not properly transfer its rights to a parent company, then are those rights in some sort of limbo state? What happens to those rights?
So the bankruptcy court in this case actually did decide that the rights were transferred. So the issue was laid to rest. We took the position that the evidentiary burden wasn't met, but we didn't really challenge the finding on appeal. So the finding stands. So from the point of view of a lender or a licensee that's going to use and rely on the chain of title they were probably satisfied because there was a finding by the bankruptcy court that the rights were in fact transferred. So I don't think the issue's in limbo.
Got it. And the next question I think may have already been answered in an earlier question, but just to give you a chance to respond, Cohen's entertainment attorney failed to insert the word material before obligation. What if he had?
Right. I don't think that I don't think that the entertainment attorney would have inserted that word. I think that maybe the Weinstein company would have inserted the word. But either way, I think it would have made the argument a little bit more difficult to make that the contract is executory, because then you would have the qualifier material, which would bring us back to the original point, which is it in fact material, as opposed to just a simple breach where complete performance is required.
Got it.
So,
and the last question, which I think will make us all happy, is would it be possible to do a sequel to this program that covers other 365 and issues?
Sure, it's possible.
Yeah, absolutely. I think 365N, Tempnology, there's definitely a bunch of interesting intellectual property and non-intellectual property issues that we could touch on, from the bankruptcy section's perspective.
Got it. Well, that is the last of the questions. Thank you, everyone, for attending. I know we have all learned a lot in developing this program, and we hope that you learned a lot in the hour that we've just spent. Of course, like I said, there will be you should have program materials, and everyone will receive their MCLE certificates via email within 24 hours. In that email will also be a link to a survey of the program. So if you could please fill that out, we would greatly appreciate it. And with that, we all hope you have a nice day.
Thank you very much.
You all.
Thank
Thank
you.
you all.